going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, what did you say?
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you guys are having a great day so far. Happy Saturday. Happy Saturday. All right. I've got 3 cases for you today. Yeah, they're all good. You guys want to watch in court? I want to watch in court. Hey, welcome. Oh, not you, Jedi. Weirdo. Blanche D. Welcome to your first live. But hi, Jedi. Good to see you too. And thank you for the Venmo yesterday. I appreciate it. Sorry I didn't see it till after the stream, but thank you, Jedi. All right. You are right, Jonathan. All right. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Hi, versus Martin Stewart.
Good afternoon, Your Honor. You're on behalf of probation.
Pretty good, Your Honor. John, I got to bring me up.
Oh, real quick on this one. The audio was terrible, so I put the volume up. It kind of creates a little bit of feedback, but I turned the volume up as high as it could go, so that way you guys could turn it down. That way, you could have a little control over it. But the volume was terrible on this one.
Mr. Stewart stands to my right.
Mr. Stewart, your first and last name? Martin Stewart. All right. Date, time, set for violation. You hear that?
Judge, I didn't speak about anything.
That's right.
Oh, sorry. Yes, Your Honor. The defendant testified for benzodiazepines on August 1st of 2024. He failed to enroll and complete intensive outpatient as ordered.
All right. Mr. Hearing.
Judge, as to the hearing itself, I did speak with Mr. Stewart regarding his right to a contested hearing, what the burden of proof is at that hearing. What we talked about are the 2 allegations, Judge, the failed to enroll in IL.
Yeah, Saturdays are usually pretty slow. I generally, since I stream at night, when I stream during the day, they're, we just get to hang out, little personal crowd. Also, there's a lot of channels live right now. I know. I'll Talk with Mike was playing a Daryl Brooks case, and he had almost 2,000 people in there. So, yeah, I feel like it's going to be a light day, which is fine. We can just, cozy up, be a little bit more intimate. No, that was weird.
That, in fact, is true. There's a reason behind it, but I believe that he will admit that's true. As to the testing, whether the testing agency is correct or not, I don't know that he's fighting the fact that there was a test positive for benzodiazepines, but there is a reason for it, and it's a prescription that would have caused that, is what he believes.
All right. So I know there was, I don't know, maybe you're not aware of this or not, there was some communication with this, right? Have you seen that email?
Yes, regarding.
So it sounds to me, and because I reviewed the email, and it sounds to me like while there was a prescription, there was also something that was potentially consumed that we don't really know what it was.
Absolutely, Judge, and frankly, the first thing that struck me from that is the outright honesty that he provided probation regarding that, because certainly he didn't have to admit to that he went out, and there's a reason for that as well, Judge, and we'll get to that at the appropriate time. But yes, he will tell this court what he told probation, that his shot was late. He has a monthly shot, not Vivitrol, but it's in that family. And I don't know the science of it, Judge, and I certainly haven't been in his position as an addict. But when it gets to the point where the shot is late, and the outfit that provides that shot didn't have it, he said there was some employee internal problems there, and on the day that he's supposed to get it, on his monthly date, they were not going to give it to him. And he started going through withdrawals, and he was had to correct it. And so that's when he went and as he told probation, tried to find it on the street to relieve the withdrawal symptoms that he was starting to feel. And what he believes was a fake drug, that he sold something that wasn't, in fact, what it was purported to be, which is oxycodone. However, he does have a valid prescription, which I believe he provided to probation today, for trazodone. And I don't know, I believe that can cause the false positive for benzodiazepine. So it's kind of complicated in that sense, but he's not trying to shirk his duty to be honest with probation. I think he has been incredibly honest throughout the whole process to this point.
Frankly, you know, the path that we've taken to get here, the recommendation from probation, that's an important point for me. I mean, if that's potentially that prescribed medication popped up as this positive substance in his drug test, that makes a difference to me. So I guess if that's where we're going, I kind of need to have a hearing. I don't know if the testing agency would be able to confirm or deny that, or just they're just going to be able to say this is the test and this is the result.
I have it in here, but I know I have it in my email of things that they put next to it, like what can cause a positive test, but I don't believe I have it here, but I do have it in my email.
Okay.
I
I don't know, maybe would you guys approach it?
Oh no, I don't think I fast forward the approach. If you're talking about the Jedi emote, that's a members only. But yeah, so this guy tested positive for a benzo, and his excuse was he didn't get his daily withdrawal shot, so he went and bought it on the street. I mean, I guess if you're that bad off, then yeah, I mean, I can kind of see that. It's not going to work. You're going to test positive for something, and of course, not going to like it. I think they just said a benzo. I don't know if they actually said what it was. All I heard was benzo. But this is I had to turn the volume down because it's really loud in my ear. So you guys may have heard something I didn't. Yeah, so this is I can talk to you. If it lasts for more than 30 seconds, then I'll fast forward it. But I did actually put a Judge Perkins clip together that I'm probably going to release tonight or tomorrow, where I fast forwarded about 10 minutes of time that they were reading off tickets. This one guy had 32 tickets, and they read them all on the record. It took forever. It was about 10 minutes, but I did fast forward that. So see, I am learning. All right, we'll fast forward.
With an explanation as well. Is that true? Yeah.
Mr. Stewart, raise your hand. All right.
Here we go.
So then, after that discussion at the bench, my understanding is Mr. Stewart would then be willing to admit testing positive for the benzodiazepine with his explanation, and also admit to failing to enroll and complete the IOP as ordered.
With an explanation as well. Is that true? Yeah.
Mr. Stewart, raise your right hand, please. You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yeah.
You put your hand down. Mr. Stewart, you're on probation to the district court for controlled substance possession, as well as operating while intoxicated. Your term of probation is 24 months. You understand that?
Yeah.
There's allegations that you violated your probation. You have a right to a contested hearing on those allegations, where it need to be shown by the preponderance of the evidence that you did in fact violate. You understand that, right?
Yeah.
My understanding is that you're going to waive your right to the hearing and instead plead guilty. Is that true?
Yeah.
Has anyone made you any promises or threatened you in any way to convince you to give up your right to the hearing?
No.
You understand you could be sentenced up to 365 days in jail and fined $1,000 plus costs as a result of these violations?
Yeah.
As to the allegation that you tested positive for benzodiazepine on 8/1/24, how do you plead?
Oh, I tested positive. Yes.
All right, you plead guilty then?
Yes.
All right. And the allegation that you failed to enroll and complete an IOP, an intensive outpatient program as ordered, how do you plead? Guilty?
Yes.
Are you satisfied, Mr. Hack?
Such a thing
That's right.
Yes, Your Honor.
Court two satisfied, but please knowing, voluntary, and accurate, I'll accept the same. Ms. Wright, your recommendation?
At this time, probation recommends to serve 365 days jail forthwith after 30 days served. Suspend remaining jail sanction for participation in the ETI program and successfully complete that program and the remaining jail sanction. Discharge from probation without improvement and waive remaining balance of court fines costs.
Judge, I've been before you, I don't know how many times, enough to know that this court never punishes the addiction. And certainly that's what we're dealing with here with Monty Stewart. He's been fighting this on a daily basis since he started the probation. This has been a monkey on his back for I don't even know how long. And at this point, I think he's kind of proud of how he's been approaching it because he's gotten himself enrolled in a program where he gets that monthly shot and he's dealing with the addiction. The problem is the program failed him. And so even a day, 2 days, in this case, it was 4 days after he was due to get the shot, that's when the demons come back and the body reacts. And the body says, I need this, you need to feed me. And that's what he did. He went out to feed the addiction, Judge, because the preventative measure wasn't available to him. It's just so unfortunate. And so he stands before you in violation because he did what he had to do to really live. And so there's so many things going on in his life now. As the court knows, he's a business owner. He actually owns the shop. He's owned it for I don't know how many years now. How many years I get?
About 21 years.
And so he has that obligation to care for and all the obligations with this court. When I read the report, Judge, I was actually surprised because the first thing I always look at is when was my client sentenced? It's been about 7 months since he's been sentenced. And when I look at all the things that he has accomplished in that time, I thought he was doing great. And so we talked about what happened, and that was the reason for him going out onto the street, which again, he did not have to admit, but he was absolutely open and honest about that, trying to fix the problem. The fact that he didn't get into the intensive outpatient program, one, he's overwhelmed, I think.
Yeah, I was just gonna say they're focusing way too hard on the drug story, and you know what? It might be true. He still went on the street and bought something. Come on, man. Come on. But he's being honest about it. You know, if he was upfront about it right when it happened, yeah, or was it after he tested positive? See, that's the thing. But they were skipping over. He didn't do his intensive outpatient. The judge is not going to be like that. This judge is not going to like that because those things, the intensive outpatients they're long. They're like 6 months, aren't they? Like 3 to 6 months. And he didn't. Well, maybe he started and left early. I think they said. Yeah, the judge isn't going to like that. That's going to be a direct smack to the face. That's what you should be focusing on.
But two, he's doing what he called an intensive group program now. He feels that that is something that's really been beneficial for him, and that he just couldn't be overwhelmed by adding something onto his plate that he didn't think more than he was already getting out of the group program. I understand the recommendation, Judge. I know that money wants to be done as well, because this is just it's just a process that sometimes doesn't work for my clients. And I think for him at this point, his battle is with the addiction. That's where he needs to focus. And so, as I said, I know this court doesn't punish the addiction. And that's what I'm hoping you look at here, is that that's really what we're dealing with. He's not thumbing his nose at the court. He did nothing really to, I think, rate any kind of incarceration sentence. I understand the court's position put forth at the bench that he did go to the outpatient program, and the issue with Mapleview is he checked himself out before finishing that program. That's not his intent now, Judge, because he's now suffered that event that caused him to know that without the oversight, without that help, he's not going to beat this addiction. And the only thing he wants to do is beat the addiction. Overwhelms probation, overwhelms everything else, including his work. This is his goal. And so he, I think, can accomplish that if the court would let him check himself back into Mapleview. He said that he has insurance that would cover it. He understands there are programs that are at least 28 days. He's absolutely willing to do that to get the tools that he needs beyond that monthly shot to help him defeat the demons that have been overwhelming him for years now. So I'm asking the court to not impose the ATI program. Instead, let him do this when he brings proof back to the court, then let him be done with probation at that point, and whatever the amount owed, if he's able to pay it, that's great. If not, to put it on your show cause docket.
All right, Mr. Stewart.
All right. Yeah, you heard what the attorney said. Legal Fiction nailed it. It's the addiction's fault, and as you know, we don't punish someone for their addiction. I mean, it's contradictory right there. And if this is all this case was, there wasn't any drama in this. If the judge didn't have anything good to say, I wouldn't have put this video in. But, yep, we're going to get some good lines from the judge. Here we go.
Anything you want to say before the court addresses the sentence?
Yeah, first, when I left the ATI program, she already know that the morning that I turned myself in, my shop had got hit by a drunk driver. It tore the whole front out.
I saw the pictures.
Yeah. So when I was in there, I couldn't get any insurance things. I couldn't get nothing done. At this point in time, it was getting so severe because my workers couldn't work or nothing. I asked a nurse, you know, and I asked her to get in contact with my probation officer, whatever it may be. That was the reason I had went out, because it was just so severe on the outside. Otherwise, I would have stayed. Secondly, when I was in there, when you know they give you a test every day in there, and then when I got out, benzodiazepines had came with my drug test for QDH as well. And the doctor was told me exactly why I would come up because of what I had at Lakeview. I know trazodone is not a benzopine, but it does show that it was false positive. I didn't take no Xanax or nothing. I never did it. So I don't even know why it would even come up now. But I know, like I said, when I went and took tried to buy the oxycodone on the street, it still didn't cure nothing because I still was sick. That's when I was telling you that when I remember when I dropped that at QDH, it had to come from that. Like, that's what the doctor told me, and I told her to call the doctor just to check it.
All right. Well, Mr. Stewart, I think the biggest issue here is that even just the way you talk about buying something off the street, I mean, that is Russian roulette. I mean, you don't know what that is you're putting in your body. I mean, so many people, we read about the news all the time. Somebody takes a pill, it's got something in it that they weren't expecting, and they're dead. They just shot dead. Right? Russian roulette, every single time you do that. And even today, talking to me, it just comes on across as kind of normal when you're seeing. And that's just not right. That's just not right. It's dangerous to you, it's dangerous to everyone else involved in this, okay? We've given you a lot of chances to do this on your terms. And to figure this out in a way that didn't upset your life and your business. But we're to the point now where, you know, drastic change needs to happen. That's just the way it is.
Well, where did I violate? Because the benzodiazepines, asked the doctor. The doctor told me this.
You didn't complete the IOP.
Okay.
Okay. You tested positive for something that you're not supposed to. You checked yourself. Really, you checked yourself out of something I told you to attend and complete. And yeah, you explained why, but you had to do that. And then we made alterations to that to allow you to instead do the IOP program. And you didn't do that. And then you relapsed. Okay.
The IOP.
So this is what my decision to make, okay? You're gonna go into the ATI program. I'm sentencing you to 365 days in the Oakland County Jail. I'm suspending it immediately so that you can complete this ATI program, which is an intensive inpatient program. But if you don't complete that, if you walk yourself out of that.
What is with all the typing lately? It is driving me crazy. I know I increased the volume of this so we can hear it a lot louder, but man, I don't want to hear a keyboard for weeks. Why doesn't everyone have a silent keyboard? I thought they're standard now.
That program, there's 365 days that you need to complete. So this program is what's going to keep you out of a whole year in Oakland County Jail. That's how important I think it is for you to do that. All right. If you successfully complete that, that'll keep the remaining jail sanction suspended. You're discharged from probation without improvement. And I am going to waive it down to the fines and costs. I don't know how much more of a treatment approach, a treatment gift we can give you in this situation. I just wanted to wait $2,700 for you to go do an inpatient program. So I just hope you see that as what it is. So that's the lucky said.
Judge, may I ask one thing? And I know we've asked for a lot. He has a business, obviously, he talked about the business, you know about the business. He needs, and I don't believe he was expecting to be walked out of the back doors today. Would the court consider allowing him to check himself back in here or to the jail on a specific day so he can wrap up his business and make sure things are right when he gets out?
I was wrong, my wife, I didn't know that.
Mr. Stewart, you know, I make all kinds of accommodations for all kinds of situations. This one, I just feel like this is the right way to go.
I'll take my car back, I'll just come back to jail.
You can make a phone call from back there. I'm sure our court officer will help you out with that. But today's the day. I know we're running late. I know everybody's in here for a trial. I have one non-public case I have to take care of, and then we're done.
All right. That was case number 1. All right. That typing. Yeah, I can't even think now. All I hear is click, click, clickety, click, 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 click. Let's just go on. Let's move on. Who are we going? Oh, we're going to Wisconsin. Jedi's home. This is a DUI case, and this
I got
is
their
interesting.
systems down anyway.
Somebody said they're gonna look into it and call Mary when they get an answer for me.
Thank you. I appreciate that, Mr. Chapman. Thank you, Ms. Molson. We will go on the record in the matter 23 TR 1002 24 CT 01, State of Wisconsin versus Joshua Davis. The state appears through District Attorney James Renicky in person. Mr. Davis appears in person with counsel Daniel Chapman. We're here for a plea and sentencing because it's set for a plea and sentencing, and I have noticed you've done all you needed to do with the IDIP program, so that's good and that's positive. But I've been informed that this may or may not proceed as a plea today. Mr. Chapman, do you want me to turn it over to Mr. Davis?
I will just say that I am not prepared to do a plea today. Mr. Davis would like to speak. I am going to advise him not to talk about the facts of the case, but if he wants to, that's up to him.
All right, Mr. Davis, you've heard the warning from Mr. Chapman, because anything that you say in here can be used against you, and that any offer or any deal that's been extended could be retracted or taken away. But so you have that warning, and I'm not going to say you seem a little hot. Something's bothering you today. I'm just going to ask that when you can say your piece, you can say what you need to say, but just please be so respectfully.
I will try to be very eloquent
Okay.
and elegant.
Okay.
I am accepting this plea. Let's get that clear right now. But I want it on record that I am actually accepting this plea under a little bit of a personal whatever.
Personal, like you have angst about.
I have a little bit of angst about it, yes. And I need to just, I'm going to get into some specifics because I haven't been allowed to speak, and well, we've been going on with this for what, 9-10 months now at this point in juncture. That December 3rd, everybody in town, everybody knows that I open the Pheasant Inn every Saturday and Sunday. I am there at 10 a.m. That Sunday, the Packers played the Chiefs. I was there at 10 a.m. I had the bar open at 11 a.m. I do not drink behind the bar. And I want to be very clear that my character and my integrity is actually the most important thing I have. I got done at 6 o'clock. Our bartender that followed up, that nobody's called. Nobody's called to speak to the bartender who actually served me in that bar that night. Knows very clearly exactly what I drank and did not drink. I was there from 6 o'clock to 9:30, just after halftime of the Kansas City Chief game, merely because the owners of the bar were at the game and had requested that I stay there and help the new bartender with the extracurricular things we do during football games. I stayed until 9:30. I went home. I was making a taco casserole. I forgot my glasses and my stuff in a Crown Royal bag behind the bar. I went back to the bar to get my glasses. The incident happened. I'm not going to go one way direction or the other on this whole thing. But at this point in juncture, it's 10:15 at night. So I've been in that bar from 6 to 10:15 at night.
The Packers did. The Packers won 27-19. I just looked it up. You just made me interested. So they're all celebrating. The Packers won.
On very minimal alcohol drinking, which is not being brought up because everybody's arguing a case based on police cameras. Look, we have one thing in common in this building. I've taken enough justice studies. I don't have my JD, but I was coming close to finishing my justice studies degree. We all have learned it's not what you know, it's what you can prove. We had cameras, brand new camera system put into the Pheasant Inn. That was right after that huge electrical storm that knocked out all our TVs and all our old cameras. I had requested Chris Peterson, the owner of the building, to monitor those cameras and pull up the film from the time that I walked into that bar to the time that I left that bar. He unfortunately didn't know how to operate the camera system, so he couldn't figure out how to put it onto a USB. So then I requested of the secondary owner to do the same thing. But I'm going to be eloquent. He didn't get around to it until it was 4 hours too late to pull the film because it started to rewrite.
Yes.
So now I have no proof of exactly what I actually drank in the bar, regardless of what was said in front of the officer on his body cam. It doesn't really matter what I say on the body cam. It's what I can physically prove, and that was my proof. My proof was right there.
You guys are welcome. Editing mistake. While I'm paused, Shane, thank you so much for becoming a new member. That is awesome. Thank you so much, Shane. I appreciate it. Welcome to the family. And Heather, thank you for the 5 gifted memberships. I appreciate it. And welcome to the 5 new members. Thank you so much, Heather. Okay, let's see if I fast forwarded through this.
It's what I can physically prove, and that was my proof. My proof was right there. The bartender has been adamant from day one, which I've told people exactly what she served me. Now, I don't know about this industry, but I do know about the bartend industry. We don't remember names, but we remember what you drank, and we remember how much you drank. That's just the way that industry goes. So my physical proof to prove that 0.152 is an impossible blood test, it's impossible. By the time they tested me, it was 11 o'clock at night. 5 hours later, based on what I know for a fact I drank, there's no possible way I could be a 0.152, even if I hadn't eaten since 10 a.m. that morning. I did not drink at home. I was not a drinker previous to this, not a predominant one by any stretch of the imagination. Certainly haven't been one after. There's just no way. The only reason that I am accepting this plea is I do not have the personal finances to fight this blood test. Now, I talked to Pat Stengel down in Madison. He's not a friend of mine, but he's an acquaintance of a friend of mine. And I went through all this stuff with him. Pat Stengel was very clear with me that mistakes happen from the point they take the blood. I have no idea what happened to my blood from the point I walked out of that room. I have no idea how long it sat on a counter. I have no idea how long it took for him to put it back into a cooler. I don't know how long it took for him to get it down to Madison, how it got down to Madison. I don't know what happened to it when it sat in Madison. But I know, based on what I personally know, and I have a bartender that knows for.
LB, you think she's stuck on the space shuttle? 2 cents? That might be 2 cents. She's definitely out of the jurisdiction though. Robert Cologne in Germany. Thank you so much for the 5 gifted memberships. I appreciate it, buddy. And welcome to the 5 new members. Thank you so much, Robert. All right, let's keep going. No more bad jokes.
For fact, and I have a bar owner who saw the film that knows for a fact what I drank. I do not drink at home. I certainly couldn't drink enough in 45 minutes, or not even 45 minutes, while making a taco casserole, which, by the way, because of this incident, burned in my house, and it took a week to get that smell out of there. There's no way. There's no possible way I could be a 0.152. Period. It's impossible. I am a 210-pound, 6'1.5" person. There's no way. There's no way. Now, the bartender on that day was very clear that she served me 3 Coors Banquets and 2 Blackberry Brandy shots, of which I left half a Coors Banquet sitting on the edge of the bar with a tip. Chris Peterson watched the film, same thing. But because I do not have that film, I cannot prove, and I have the film for my house. My whole house is wired up with cameras. I wasn't drinking at home. So how I could, from 6 o'clock at night when I got done with my shift to 11 or 11:10 when they finally took my blood, have a 0.152 is above and beyond. That's like technically not possible. It's not physically possible. It's not biologically possible. I am going to accept this plea because I have much bigger things in my life that I need to deal with. I build compensated communities when I'm not a bartender. I have people that rely on me. I will go sit in jail. But I wanted it on record that I'm accepting this plea because I can't technically prove my innocence. But our bartender, the bartender with the server, she just walked out of the building. To this day, nobody's ever even called the bartender and asked her. You just merely just asked her, what did you serve them that night? So here I am accepting something based basically on body cams. Look, I'll be the first one to tell you, and I'm just an honest human being. I'm not a big fan of our police. Why am I not a big fan of our police? Because my what do they call that? My living relies on the police not hanging around my bar all night long. And I've watched my living since November of last year go from here down to here because nobody wants to come into town anymore. So at the time that I got pulled over in December with them, you know what? Here's the thing. They couldn't give me a speed limit. They said I was in prudent speed. There wasn't anybody in town. I live over behind the ball field. Everybody knows that goes from a 40 down to a 30 very quickly right there. Perhaps I was slightly over. I don't know. Nobody can tell me. Then they make a big scene in the report, like they had to burn carbon to catch up to me. The two officers were sitting in the community bank chitty-chatting with each other, which is what they always do. It's exactly 0.2 miles from the community bank where they're sitting to the Pheasant Inn parking lot. I don't think anybody had to burn carbon to catch up to me. As a matter of fact, I was parked in the parking lot of the Pheasant Inn and out of my car, I think, or at least getting out of my car, when they pulled in the wrong way into the side parking lot and then turned their lights on. So the whole idea that I was flying through town at 75 miles an hour at some huge imprudent speed is a little bit, in my opinion, a little bit ridiculous. Doesn't have to be their opinions, whatever. We can't prove that either. But I know for a fact what I drank because I was not a drinker. Everybody who's known me for the last 2 years knows that this is what it came down to, Your Honor. I decided 2.5 years ago when I did drive home, ripped, that if the only way I could have friends or a relationship in this county was to drink or be at the bars, I was done. I don't hang out at bars. I do not go to bars except when I'm working, and when I'm done working, everybody there knows that I pack my stuff up and I leave. I don't take my free drink. I don't take nothing. I got a car full of like 50 bar chips for the Pheasant Inn alone because I don't drink. So I will accept this plea regardless of what he says, and I will accept whatever you put. I just want it on record that I am not in full agreement based on my integrity and my character and knowing darn well that I was not drunk that night and there's no way I could have a .152. And I have mentioned that and argued that from the day this has came up. I do not want to put anybody in a position where you look at them and say, okay, well, somebody's not doing something. I'm not here to do that either. I'm just here to clearly state something that I've been trying to state for 9 months. And nobody is listening. So that was it. I will accept the plea.
Oh, trust me, we have people listening. I think we're tired of listening, but we're listening.
I paid the money. I did 80 plus hours of community service. I tried to do a little extra not to have to go sit in jail for 2 days because, to be honest with each other, I'm a productive member of this community, working with a lot of members of this community, trying to help a lot of members of this community. I have been a very responsible bartender my whole career here. I've never had any problems as a bartender, ever. You don't have the police called when I'm bartending. You don't have underage people coming when I'm bartending. Me sitting in jail for 2 days to be an unproductive human being is just, I don't know. It's just, if that's some liberal thing that the Madison people came up with, fine, so be it. But it's just ridiculous. But I'm going to tell you, all I guess I want to clarify is there's no possible way I could be a .152 when that blood test was taken. So that was it. But I will accept this plea, regardless of what he has to say.
Thank you, Mr. Davis. That was a lot, and it's a lot to sink in and to hear. And I can definitely hear from what you went through and what you've been through and knowing yourself that I can't say anything, but I'm in this chair. I have to follow the law. I have to enforce the law, and I have to rely upon science.
Mm-hmm.
And the only way I get to hear anything, and anyone gets to hear anything about the cases, is through the jury trial in which the lab analysts will go over.
Jed, I get what you're saying, but he did admit to drinking. He admitted to driving. So that's enough for a DUI. He said exactly how much he had on the record. What he's saying is he wasn't above the legal limit is what he's fighting, but he can't fight it. That's what he's trying to say. But he already admitted to everything you need to admit to, except for the actual blood alcohol level. So I think there's enough there to take the plea. I do.
Step by step, and the officers will go over step by step of when the blood was taken, how it was packaged, how it was mailed, how it was received, where it went after that, how long it was stored before it was ran.
It seems to me, and I'm not trying to interrupt you, that this is something that should have been looked into way before this.
And see,
And I've seen nothing.
I don't, and so you can understand when I get to cases, the only way I get facts, like true facts and all of the information, which is called the discovery and those things, is through a trial or through other hearings that could possibly come into play. And we haven't had a trial, so I don't have any of the information that you're talking about. I just know the basic facts of the allegations that occurred on December 3rd, 2023, which goes into the start of when you were first picked up, what happened with the blood draw and the transport, again, at least through the officer's perspective, which is probably a combined total of 2.25 pages of a narrative. Those are the facts that I get from the case, other than what's argued to me from both sides, and what's argued or I don't want to say argued, but told to me by the defendant. Okay. And so my job here is to make sure that I understand you're accepting the plea, and you're essentially saying, I'm backed in a corner. I want to get this done. I don't have the funds to fight this. But I need to make sure that you understand that, at least from my perspective, where I'm coming from, I have the narrative from the law enforcement officers, the arguments from the counsel, and again, the science in a report that I don't even think I get the report. I don't think the report is even here unless I'm told, and usually I would say, okay, either Mr. Renicky or Mr. Chapman, what was the BAC? What was the blood alcohol content that night? What does the report state? That's the basic of the information that I get when I proceed in a case where I do a plea and sentencing. And so I hear where you're coming from. And it does sound like it's a big deal, and especially a big deal to you and to your reputation and to your character. But I have to make sure that you understand the ramifications of accepting a deal instead of moving forward to trial.
Well, as we know, like I said, I think we're all in agreement. It's not what you know, it's what you can prove. If I were to go to trial with a jury of 12, I might get lucky and get enough of them that I've served in the bar. Maybe not. Might be lucky enough to get enough of them where they just give me the not guilty no matter what. Who knows? Fact of the matter is that the one thing that I actually needed to not be sitting here right this second was that new camera film, which I cannot get, I do not have. And without that camera film, I have two witnesses. Whether they're gonna take the credibility of those two witnesses, one of the witnesses, you know,
Hey, Judge, how's it going? Hope you're having a great Saturday, bud. Um, I saw I've been looking at the scores for fantasy football, and I think you're gonna have a close week. I think people in court might be able to beat you this week. We'll see, though. We'll see. But good to see you, Judge.
perhaps with her own current situation, that's not gonna come across as credible. And actually, in a
I
weird,
don't know who you're talking about.
well,
Could she?
doesn't matter. The other witness also, you do know as well, you're dealing with something on that person. And the credibility of those two witnesses, because of those two situations of their own creation, I lose my credibility on banking on those two. So without the film, I'm Scrooged. I just wanted to, can I say Scrooged?
Yeah.
I just wanted to clear on record that I'm not just laying down here because I know for a fact what I did drink, regardless of what lippy stuff I said to an officer with a body cam.
Okay.
They know what I drank because they served me. I just don't have a film to be able to prove it from 10 a.m. when I opened the bar to the 9:30-ish when I left it. And does this affect me? Absolutely. I'm looking at a third offense with a fourth offense. Well, I don't drink, so it doesn't matter to me anymore, but with a fourth offense, that's a huge problem. I'm looking at a loss of my license, which is a huge problem.
She knows the penalties for an OW.
Yes, I'm very well aware.
Okay. And so you've had time to think about this. And so I'll do is,
You notice the only time he stops talking is when his attorney calls him out. Like, you don't have to tell her what the penalties are. She already knows. Oh, that means stop talking. Yep. Where were you like 10 minutes ago, bud?
I will set this aside to another date. If you're telling me you want to accept the plea, then we'll move forward that way. Otherwise, we can set it for a trial.
Judge, are you going to accept an Alfred plea on this?
Yes.
Okay.
It sounds like Mr. Davis has a lot that he contests, and he understands that in his situation that there would be enough here to prove guilt beyond a reasonable doubt because of the lack of the evidence that he believes he has. Therefore, do you understand what an Alfred plea is?
Absolutely. It means I'm not pleading guilty or unguilty or anything, but basically I'm still guilty.
I don't accept those often, Mr. Davis, but with your statement here today and the information you've provided to the court and how, I want to say, adamant you are on the night and how it occurred, I think an Alfred plea, Mr. Chapman, would be acceptable. Unless the state were to object or to wish to provide any argument as to why the court should not.
I have no objection either to a no contest plea or an Alfred plea, or a trial.
All right. So we can move forward and you can talk to your attorney further about that Alfred plea and if you wish to accept it. Mr. Chapman, I believe I have you coming back. Are you coming back in person on September 18th for that status with Ms. Shannon? Yeah, you can't work. Yes, Mr. Davis?
Let me choose my words wisely here.
Yes, I was going to be there in person.
He's going to choose his words wisely. He's been doing really good at that so far. All the extra details. I still want to know about his casserole. I actually know about his casserole. He's about to talk about it again here shortly. Don't worry. We'll find out about the casserole. Unless he already said it and I was reading chat and missed him say it. I don't think he did yet. We'll see.
October 18th to the 21st, I have to be out of state.
Well, September 18th.
Well, what I'm saying is that September 18th
Oh,
is,
he'll be in jail or.
I'll be on
house
home
arrest.
monitor system because I've given her the money and the checks for this.
Well, monitor for what?
If he's convicted on September 18th, he will be on house arrest for when he's supposed to be out of
Yes.
state in October.
And where are you going out of state?
I will be in Toledo, Ohio for a 3-day business convention from the 17th to well, we'd be back the 20th, that Sunday night sometime.
Well,
Yeah, I was reading the chat and I missed it. It happens. But yeah, I remember he said he burnt it. Oh, yeah. I mean, don't this is a note to everybody. Don't put something in the oven and leave the house. You never know what's gonna happen. You don't. Even if it's, the casserole takes an hour to bake and you're only gonna be gone 10 minutes, but if you actually physically have to drive, yeah, don't do it. You have no idea what's gonna happen. He's lucky his house or apartment or whatever didn't catch on fire. He was in jail.
I have a very complicated life. I'm not just a bartender. I also do merchant to merchant credit card services, and I'm building a business that requires me to travel.
and you wouldn't be drinking?
I don't drink. My point is this, is that I as much as it's,
Can we just do it after after he gets back in October?
Yes, we could do that. So when do you get back in October?
October 20th.
Oh, that's a long trip.
Well, it's the 17th. We will
17th,
leave on
20th.
Thursday.
It's a weekend.
The convention starts on Friday. It's
I
full
was
day
thinking,
Saturday and
yeah.
Sunday.
But
Yes.
it's late, and so he'll still be sitting some time arguably, if he's,
He will still be on house arrest at that point, even with the IDIP.
Which most likely will not allow me to leave the state.
I make the rules, so yeah, you can actually leave the state. But I
Well,
would need a whole lot more information about that trip to be able to approve it.
the inherent problem there is, according to Miss Tessa, and this is gonna be a real, even on house arrest, if I were to start this thing today and just be done with this, it's complicated because like I have to be in Rochester every month on the third week. I'm sorry, Ren, what day is that in Rochester? Saturday.
Well, again, as long as there's a lot of information that's provided to the court, things like that can be approved. It's just not, you can't go to fun things. You can't go to graduation parties and birthday parties and all of those fun kind of things.
Well, you may
because
find it hard to believe, but I don't have a lot of friends, so I don't have to worry about
it's
that.
supposed to be house arrest, but Huber, work-related things is okay. October 24th at 11:30.
I have 3 hearings in St. Croix County at 9:30. I'm probably not going to be able to get here in time.
At 2.
That would be fine.
So October 20, well, that's on a Schmidt week. I could do October 31st.
Jury trial judge.
Bad luck.
Yeah. So is it okay if we do it on a Schmidt week?
Yeah, that'd be fine.
It's
All right.
it's an IDIP recommendation, so
October 24th at 2. Anything further?
not for me, Judge.
All right, thank you. And if there is something like that that you say is within the normal course of your business that you have to travel, but it's work related and you would be on the monitor, just come prepared, have that written down of all of those things so I can review it, so I can pre-approve it to tell Ms. Anderson, I'm approving this, I'm not approving it, or doing those things, okay?
Yes.
All right. Thank you. We are adjourned.
Judge, any chance you could send a judge-to-judge message to Judge?
I think Judge Fletcher is about 15 minutes behind in the video. I've noticed his messages are a little delayed. All right, we're going to the last one. Now we're going to North Dakota. I just started watching this judge within the last couple weeks. I've covered him once or twice. I like him. But a lot of his cases are really drawn out. He doesn't talk very fast. So, you know, when you have a judge that doesn't talk fast, sometimes cases can, you know, a 5-minute case can turn into 15 minutes. But this one's good. So let's go.
Okay, thank you.
Next case the court's going to take up is State of North Dakota versus Tyrese Basco, file 37-2024 CR 60. Mr. Kelly appears on behalf of the state. Mr. Basco appears personally in court without counsel. Have a seat, sir. Mr. Basco, were you present in court when your rights were read to you?
Yes,
Do you understand your rights?
yes.
Do you have any questions about your rights, sir?
No, Your Honor.
You're charged with a misdemeanor level offense. You have the right to counsel. You have the right to hire a lawyer of your choosing. You have the right to apply for a public defender. And if you financially qualify for one, the court would appoint one for you. Or you can choose to represent yourself. How would you like to proceed?
Represent myself.
Has anyone threatened you, forced you, or coerced you, made any promises to you in order to get you to waive your right to counsel?
No,
And you understand, sir, that you can change your mind and either apply for a court-appointed attorney or hire a lawyer at any time while your case is still pending?
yes, Your Honor.
All right. So, sir, have you received a copy of the charging document?
I have.
You have the right to have that charging document read to you in its entirety, or I can summarize it for you. Are you okay with the court summarizing that document?
Yeah.
I'm sorry, I'm having a hard time.
Yes.
Okay. So on or about August 10, 2024 in the county of Ransom, the state alleges that you committed the offense of reckless driving, speed, as
That's North Dakota. It's the northern part of North Dakota. You know, northern United States, right? Or are we southern Canada? I don't know. All right. I paused it at exactly the wrong time. He is about to read what the charge is, so I'm just going to go back about 10 seconds. I gotta stop doing that.
I'm sorry, I'm having a hard time.
Yes.
Okay. So on or about August 10, 2024 in the county of Ransom, the state alleges that you committed the offense of reckless driving, speed, as charged that is a Class B misdemeanor. Class B misdemeanors carry with it a maximum possible penalty of 30 days in jail, a fine of up to $1,500 or both. There are no applicable minimum mandatory penalties for this type of offense. If you are convicted, there are certain court fees. In your case, the court fees total $250 right now. This will have adverse driving consequences for you if you're convicted, including points assessed against your license. I believe it's 8 points. If your conduct caused any financial loss or harm to another person, the court can order restitution. If you're not a U.S. citizen, this can have adverse immigration consequences. Do you understand the nature of the offense and the penalties as I've read them, sir?
Yes, Your Honor.
And to this charge, do you plead guilty or not guilty?
Plead guilty.
All right. Has anyone threatened you, forced you, or coerced you, made any promises to you in order to plead guilty?
No, Your Honor.
You understand that you don't have to plead guilty, right?
Correct.
Mr. Kelly, before I decide whether I'm going to accept the plea, can you tell me what the state would recommend if Mr. Basco would plead guilty today?
Yes, Your Honor. The offer that was given to Mr. Basco was that if he pled guilty to count 1, reckless driving, the state would dismiss count 2, the speeding. He would have 90 days unsupervised probation, $25 to the victim witness fund, $250. I think it actually should be $225 court administrative fees, and then a $125 fine.
Jedi, thank you so much. I appreciate it. Thank you for the 5 gifted memberships and welcome to the 5 new members. Thank you so much, Jedi. That's awesome.
Sorry, you mentioned count 2. I only see 1 citation filed alleging 1 count.
I'm not sure why that is. I see also, Your Honor, 1 uniform traffic citation for reckless driving.
So what's,
but in any event, if it might have been that I was planning on bringing a count 2 for the speeding, but in any event, the offer would remain the same if he pled guilty to the current charge, which is reckless driving on the uniform traffic citation.
so is it fair to say that even if you were planning to file another citation, you would not be doing so in exchange for a guilty plea to the reckless driving?
Yes, Your Honor.
All right. Sir, is that your understanding?
Yes, sir.
And that's what you want me to do, is to accept that plea?
Yes, Your Honor.
All right. Can we agree a sufficient factual basis exists based on the face of the citation 110 and a 65? That you were driving at a rate of speed or in a manner that was unsafe and reckless?
Yes, Your Honor.
All right. Mr. Kelly, anything to add with respect to a factual basis?
Just that the speed listed on the citation is actually less than the actual speed reported by the officer, but the state is fine with the factual basis being the face of the traffic ticket.
All right. And again, sir, you want me to accept the plea?
Yes, Your Honor.
All right. The court is going to accept the plea and find it freely, knowingly, and voluntarily made. The court is going to find a sufficient factual basis to support the charge as it stands. I've heard Mr. Kelly's sentencing recommendation. Sir, do you have anything that you want to tell me about the sentencing recommendation?
All right. Now we got all the, the normal court stuff out of the way. This is when it gets good. What he says and what the judge comes back at him with is good. And I feel like everyone in the chat that's going to listen to what he says is going to think exactly what the judge says. Yeah, 110 miles an hour. Why? Why? Just why? You're asking to hurt yourself, hurt somebody else. There is never an excuse to drive that fast. I'm sorry. There isn't. Unless you're on a racetrack and that's your job, or you're just on a racetrack, I guess. Anyways, I'm rambling. Philip, thank you so much, man. I appreciate the 8 months. 8 months. That is awesome. Thank you so much. I appreciate it. How many times can I say I appreciate it? I don't know, but I appreciate it.
No, Your Honor.
All right. Is there anything else that you want to tell me before I impose sentence?
Yes, Your Honor. So is there, I didn't see anything about my license being suspended today. But the officer did tell me it was gonna get suspended today. Is there any way we can, I can take classes or anything? 'Cause my mom has cancer and I drive her to her hospital appointments.
Okay. Well, you weren't rushing to the hospital at 110 miles an hour, were you?
No, it wasn't.
Okay. You're just being dumb?
Yes, sir.
Okay. And you're being dangerous. You understand that, right?
Yes, sir.
So even if you're a good driver, if you have a mechanical problem at 110 miles an hour, something bad's going to happen. You understand that, right?
Yes, sir.
Is this something you're going to do again?
No, sir.
You understand that if I see you in my courtroom again for something like this, the outcome won't be, suspended probation. You understand that, right?
Yes, sir.
All right. So in terms of the suspension, the court doesn't suspend licenses ordinarily. There are times where I can do so as a condition of probation. The Department of Transportation controls whether they suspend your license or not. I told you at the beginning that there's the potential.
Yeah, he does seem kind of humbled. He probably got an earful from the officer that night as well. And he's young. I don't remember if they said how old he was, but he looks like he's anywhere from like 18 to 24, somewhere in that range. He looks young. All right, everybody. This video only has a couple minutes left. Wait, how does it still have 5 minutes left? This is almost over. All right, looks like I'm still pausing at least one more time. Okay, let's go.
For adverse driving consequences. I believe reckless driving contains a requirement that 8 points will be assessed against your license. If you're over the age of 18, are you over the age of 18?
Yes, sir.
What's that?
Yes, sir.
Okay. So if you are an adult and you're driving, it's different for kids. So if you're under the age of 18, you have 6 points to give before they suspend your license. If you're over the age of 18, you have 12 points on your license. And so this would be 8 points against the 12. I don't know what your driving record is. If you have 4 other unrelated points, your license will be suspended by operation of law from the Department of Transportation. But a conviction for this offense does not require automatic suspension of your privileges. So I don't know what your situation is. I'm not going to give you advice on whether or not this will or will not result in a license suspension. The officer could have been talking about both the combination of reckless driving and speeding which would have also imposed certain points against your license and likely resulted in a total exceeding 12, resulting in a suspension. Do you understand?
Yes, sir.
Okay. So you're asking me to accept this plea. The court has done so. Is there anything you want to tell me before I impose sentence, sir?
No, sir.
Ah. Well, the state's moved to dismiss that, correct, Mr. Kelly?
Speeding, yes, Your Honor.
That will be dismissed. So that didn't make it on my Odyssey calendar, but it's been filed, Mr. Kelly. So that file will be dismissed in exchange for the plea. Anything else that you want to tell me, sir?
No, sir.
All right, the court is going to adopt the state's sentencing recommendation and impose sentence as follows. For reckless driving, 90 days unsupervised probation, conditioned on the payment of a $125 criminal administrative fee, $100 facility improvement fee, $25 victim witness fee, $125 fine. Actually, I'm going to make that $150 fine. Total financial obligation is $400. How do you anticipate paying the $400, sir?
Yeah, yes, I can do that.
So that wasn't my question.
Yeah. How do you anticipate paying the $400? Yeah, I'll do that. I love people's responses sometimes. Judge is like, sir, that wasn't my question. All right, now I'm gonna let this video play out. I hope you guys have a great rest of your day. Thank you so much for the gifted memberships and the membership milestones. You guys are awesome. And no Jedi, I don't think those are headphones around his neck. I think he has one of those, like, it's either a collared shirt or I think might be, yeah, it might be a collared shirt, it might be a button up, or it might be a sweater that the collar just kind of lays like that. But I don't think they're headphones. Anyways, you guys are awesome. Enjoy your Saturday, everybody. As always, I will not be streaming tonight. I will be back tomorrow night, regular scheduled time. All right, I will see you guys later. Until next time, bye.
Do you need time to pay it, or can you pay the $400 today? Do you need a payment plan?
I need time to pay it.
All right, well, you're on probation for 3 months. The entire balance needs to be paid off in 3 months. And so I usually give people a little while. Can you make your first payment by August 1, or I'm sorry, October 1?
Yes, sir.
All right, first payment on October 1 is going to be $150, with like payments due on the first of every month until it's paid in full. The entire balance of $400 needs to be paid within the 90 days of probation. And so if you do the math, it doesn't quite work out. You're going to have to make either more or sooner payments to pay it all off within those 90 days, sir. Unless I require $150 today, then we can maybe get it done in 3 months. But I'm not. I'm giving you a little time to pay this first payment, but the entire balance needs to be paid while you're on probation. Do you understand that?
Yes, sir.
Do you have any questions?
No, sir.
Mr. Kelly, did I miss anything?
No, Your Honor.
All right, that matter is adjourned. Have a good day.